Greetings and salutations, my fellow sovereigns. This is the Vocational Science Freedom Saturday Night Civics and Sovereignty class. And tonight we are going to be talking about high prerogative writs and all of the things that go along with it. Now, a high prerogative writ is a common law writ that we the people have the capacity to ask for when something is not being done correctly according to law. And there are several different types of high prerogative writs. And tonight we'll be going over a treatise on said writs, which I've posted into chat. And it is called A Treatise on the Legal Remedies of Mandamus, Prohibition, Habeas Corpus, Certiorari, and Quo Warranto by Horace G. with forms. And you always want to look for a treatise that says this, with forms, because this always helps you then create what you need to create. And this is published in 1891. And you also want to look for treatises that are always before, preferably 1913, because that's when they started to really take out the common law as they brought in their unlawful bank and then started to administer everything. So if you'd like to join the Vocational Science Freedom Gilded server, you can do so by going to the VSOF YouTube page and clicking on the link, which is right here. It's gilded.gg/VSOF. And tonight's talk will be in the self-governance quadrant out here in the outside section of the self-governance quadrant, because we're going to be talking about basically how to administer public officials. Okay, so if you guys want to open up the treatise and also the writ I put into chat, it'll be in the mega folder. And this writ of Quo Warranto is something that came to me from Viper. He's been going after, quite diligently, several judges and district attorney and even apparently the assistant attorney general of Florida, who also does not apparently have a proper oath and bond filed onto the public record. So this is what precipitated this class tonight, is him wanting me to help him put together a proper writ of Quo Warranto. Now, let's go over and open up the treatise first. Let's go down to, it should be, I believe, page 60 in the PDF. And we're going to read all of the different types of high prerogative writs that are listed in this treatise, because I want everybody to get a good understanding as to what each one of these writs actually does, because most people don't know, and even a lot of people sometimes incorrectly think that one of these types of writs is to be used for a certain purpose when it's actually a different one that they should be using. So I'll make this a little bigger here so everybody can see it. And I'll bring chat back up as well. Okay, so Chapter 1, Mandamus and Prohibition. Mandamus. General observations. The writ of mandamus is a high prerogative writ, issued in the name of the people by the Supreme Court and directed to any person, corporation, or inferior jurisdiction within the state, requiring the doing of some particular thing therein specified, which pertains to the office or duty of such person, corporation, or inferior jurisdiction, and which such court has previously determined, or at least supposed, to be consistent to right and justice. This writ is issued or withheld in the discretion of the court, and the court, in issuing it, will be governed by what seems to be necessary and proper to be done in the premises for the purposes of justice. It will not be issued in cases of doubtful right. The legal right of the party to which he demands in the writ must be clearly established, which we'll get into as far as when we read this, the writ that we have. And in to entitle the party to this writ, it must appear that there is no other specific legal remedy to which he can resort for the enforcement of his right. Where the party has an adequate remedy by action, this writ will not be awarded. Meaning, like, if you had a capacity to sue him at common law for a trespass or something else, then this is not the writ that you want to be doing, okay? So just make that clear. And it is granted only for public purposes to compel the performance of public duties. And there must have been a neglect or a refusal to perform such duties after a demand had been made for their performance. And again, this is exactly what Viper has done. He's gone and gotten FOIA requests or state open records requests, because that's what you do for the state. FOIA is technically only federal, and has asked them for their valid oaths and bonds. He's found that they don't have them. Then he's demanded that these cases be dismissed based upon the fact that, guess what? You don't have the lawful authority to be doing what you're doing at all, including but not limited to continuing to operate this court. So he's already done that. Made the demand, so therefore. Now the next point is to do the writ. It will not, to continue here, it will not be issued where it would be unavailing. Thus, it is held that a mandamus should not be granted where it would be unavailing from a want of power in the defendants, for the court should refuse the writ if it be manifest that it would be vain and fruitless. Thus, a mandamus to compel a board of canvassers to do certain acts after they had ceased to exist as a board would be futile. So get the point. Everything has to be in order. They're supposed to have something that they're supposed to do, which in this case, they clearly do. And it has to be enforceable by law. Okay. The Supreme Court may interfere to control the action of a board of canvassers while they exist as a board, but it cannot be done only while such board has a legal existence. And where a mandamus is asked, it should appear that the defendants have it yet in their power to perform the duty required of them, which would also be the case. Yes, these guys could actually go and file their proper oath and bond, but they're clearly not doing it. Thus, a mandamus should not be issued to direct commissioners of excise to entertain the application of the petitioner after the board had met and compelled the 10 days limited in the act. So again, what we're going to do here, and I'm going to show you this in the writ as we're compiling it, is that you're going to say, look, this is what you were supposed to do. You got 10 days to do it. Go get it done, right? And this is basically the Supreme Court of Florida telling them to go do this. Now, even though they do still have to do it, technically, all of the acts that they've done up to this point, because they were not properly in the office to begin with, are void ab initio, which we'll get to again in the writ. Okay, so this is mandamus. Let me then scroll down to the next one, because I just want to cover these just to give you the basics of what these are. I don't want to sit here and read the whole totality of the treatise. That would be exhaustive. So the next one is in page, and I made notes of these here so it'd be quick to find. Okay, so the next one is page 170 for Habeas Corpus. So 170, click go. Okay. Chapter 2, Habeas Corpus, and I'm never exactly sure how to pronounce this correctly. I think it's Certiorari, I think is correct, but don't hold me to that. Okay, so general observations. The writ of habeas corpus is issued to inquire into the grounds upon which any person is restrained of his liberty, and when it is found that the restraint is illegal, to deliver him from such restraint. There's also other ways to use a habeas corpus, but I won't get into that right now. A person imprisoned or restrained in his liberty within the state for any cause or upon any pretense is entitled, except in one of the cases specified in the next section, to a writ of habeas corpus or a writ of certiorari, as prescribed in this article, for the purpose of inquiring into the cause of the imprisonment or restraint, and, in a case prescribed by law, of delivering him therefrom. A writ of habeas corpus may be issued and served under this section on the first day of the week, commonly called Sunday, but it cannot be made returnable on that day. If you want to get into the understanding of how writs work and the process, there's a different treatise that I think I did add to the megafile for this class, and that treatise covers the process of what a writ is. And it covers a process not so much as high prerogative writs that we're talking about here in this treatise, but more along the lines of just how general writs were sued out in court at law. Because in an action at law, what is supposed to happen first is that there's supposed to be a writ that issues. The plaintiff writes up the writ, they file it, and then they have the sheriff serve the writ onto the defendant. And it doesn't show like the totality of the whole case. What it does say is that this is why you're being summoned. And this is, again, where a summons comes from. It comes from an original writ of summons at law. And then later on, equity kind of adopted it and kind of turned it into a slight bastardization of what it originally was. But again, I don't want to get into all that either. When you get a summons from the standpoint of equity, to summons to go to court, that's like the bastardization process of it. If you were to have properly been summoned to court, you would get a writ of summons to go to court. But obviously no one knows how to even so much as operate in common law anymore, and none of the attorneys have ever bothered to learn any of the process as far as how you're supposed to do this at law. But I just thought that was an important thing to bring up. And if you really do want to understand, again, some of these words, like what they're talking about as far as the word issue, the word return, and some of these other things that deal specifically with writs at common law, that other treatise is a much better book to just go ahead and read the whole thing. It's an amazing book to read about what a writ is in general. Okay, so writ of habeas corpus may be issued and served under the section for, okay, so we read that. The right to relief from unlawful imprisonment by habeas corpus is not the creation of the statute, but exists by common law. Okay, I want everybody to make a very clear point about that, to understand that point. Is not the creation of the statute, but exists by common law. When you do a writ of habeas corpus, when you do a writ of assert or mandamus or any of these other, Quo Warranto, any of these other things we're going to be talking about tonight, you want to do it at law. Do not ever use a statute to state that that is your authority for the writ. It's like stating that the janitor told me I could do it when you're in a corporation. It exists before the charter of the corporation exists. And literally, from the standpoint of the charterability of government and even the constitutions, both state and federal. These writs exist prior to these governments even coming into existence, okay? So they exist at common law, and you never, ever want to use a statute as your authority as to why you're filing a particular high prerogative writ. All right, to continue. Where a person is restrained of his liberty, previous adjudications on habeas are no answer to a new writ. The question of the sanity of a person confined in an insane asylum may be tried by this writ. This is another aspect of what you can do with habeas. So a person confined under a commitment void on its face, but not one confined under a void sentence, but a valid conviction. Okay, that's another interesting point too. I ought to break that down for a second. So a person confined under a commitment void on its face. So let's take an example of a warrant, just an arrest warrant. So some cop comes up to you. I got a warrant for your arrest. Your name's John Doe, blah, 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 whatever. Come with me, right? Well, you say, well, I demand to see the warrant. He's like, well, I don't have it. He's like, well, I'm not going with you if you don't have it. And, you know, you could have a gunfight right there, literally, and you'd be in the right and he'd be in the wrong. But let's not go down that road at the moment. Say he gives you the copy of the warrant, but say it's not signed. Okay. Is a warrant not signed valid? Nope. That means it is void on its face. That's one of the things that makes an arrest warrant void on its face, as far as any of these other aspects of writs would also be concerned as well, or anything else that is a order of the court. If it's not signed, it's not valid. It is void on its face, okay? But one not confined under a void sentence, but a valid conviction. So, again, you could even have an aspect of being a void sentence. So something didn't properly happen during the court procedure. Someone had their rights taken away from them, say they didn't have the right to defend themselves or whatever it may be. That would be a void sentence. So you have things that are void on their face, you have void sentences, but then obviously an aspect of a valid conviction. Okay, fine. You can still do a writ of habeas corpus to say, well, was the sentence even valid? Right. A person is not entitled to either the writs specified in the last section in either of the following cases. 1, where he has been committed or is detained by virtue of a mandate issued by a court or judge of the United States in a case where such courts or judges have exclusive jurisdiction under the laws of the United States or have acquired exclusive jurisdiction by the commencement of legal proceedings in such a court. A example of this would, say, be adroit in admiralty, because federal courts have exclusive jurisdiction in admiralty. That would be one example of this. 2, where he has been committed or is detained by virtue of the final judgment or decree of a competent tribunal of civil or criminal jurisdiction, or the final order of such a tribunal made in a special proceeding instituted for any cause except to punish him for a contempt, or by virtue of an execution or other process issued upon such a judgment, decree, or final order. So basically what this is saying is that if it's been done correctly, if everything was properly done, if he's been committed, detained, or virtue of a final judgment or decree of a competent tribunal, that's the point there, of a competent tribunal of civil or criminal jurisdiction of final order, blah, 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 made special proceeding, okay, is all good. So if everything's all good and finished, then a person is not entitled to a writ of habeas corpus. He's entitled to the writ of habeas corpus until final judgment or until final order or decree. Up until that point, you can still do a habeas. But once final judgment's done, that was your window, then nope, it's over. Then all you've got after that is either appeals or a very extraordinary writ, which is not even listed in this treatise because most people don't even know about it. In fact, I dare to say every attorney in the world probably doesn't even know about it. And that's called a writ of attaint. A writ of attaint is a writ where you file this writ directly with a 25-member grand jury. And what the grand jury decides to do is they look into the previous court case, even if it's gone all the way to final decree and final judgment, doesn't matter. And you bring something up to the grand jury and say, hey, wait, hold on. It might have been a final order, but what they did in this court was incorrect, or they didn't have jurisdiction because of this reason and no one paid any attention, or for whatever other reason, lawful reason that this court didn't do what they were supposed to do. And then the grand jury retries the entire case on its merits. And sorry, all you attorneys out there, but there's nothing any of you can do about it. There's nothing any judge can do about it. There's nothing even the Supreme Court can do about it. Now, why is nobody using this? Well, because nobody knows about it. And because it was used several times in the colonial period, and obviously the attorneys and the Khazarian mob didn't like that very much, so they basically erased it from history. But I still have a few treatises of which it is mentioned, and then I started to look it up, and it exists. So, okay, I think that'll be, well, let me see what else here. In general, this writ to inquire into the cause of detention in all cases, whether under a statute or at the common law, except when issued by the Supreme Court or of one of the justices thereof, can only be allowed for the purpose of delivering the person for whose relief is asked from the illegal imprisonment or restraint. Right, because you can't pull, like, say, you can't do a habeas corpus and say, I want everybody that's incarcerated in said prison, brought in on habeas corpus. You can't do that. It has to be only delivering the person for whose relief it seeks. The only exception in this case of an infant of such tender years as to be incapable of making a choice for itself. Okay, but that'd still be just one infant. Okay, well, I don't know what they're getting at there. While the writ of habeas corpus is prerogative in its character. Okay, what's prerogative? All right, prerogative means that we, the people, just decide to do it. By the king's prerogative. By our sovereign prerogative. We feel like it. That's what a prerogative writ means, because you want to do in your sovereign capacity. In its character, it is nevertheless a writ demandable as of right on a proper foundation being made out of proof. Right, so proof that that the detention was unlawful, that, say, the warrant was void ab initio, or for whatever reason, right? And it lies in all cases of imprisonment by commitment, detention, confinement, or restrainment for whatever cause or under whatever pretense. That's the most important thing. I don't give a flying fuck why he's imprisoned. Habeas corpus will automatically cover it. Habeas corpus is one of the few writs. Really, habeas corpus is probably the only writ that got stronger and stronger over time under the common law. And the reason is because that it was used for a long time in English jurisprudence as a territorial fight between various different jurisdictions of court. Say, between Chancery and King's Bench, or some ecclesiastical court was maybe holding somebody, and somebody filed a writ of habeas corpus and said, no, this is supposed to be in King's Bench, or nope, this is supposed to be at law. And then the at law courts would see whatever it was that the ecclesiastical courts or the Chancery Court was up to, or even the Admiralty Court was up to, and they'd say, no, that belongs over here, meaning we're going to take away your power to hear that case. So in a very weird sense, that's the reason it got stronger over time, because the various different courts used it against other courts to expand their own power. It had this odd history to it that, one, a lot of people don't know about, but that's what made it more powerful over time, which why it then encompasses all of this aspect. In case of any imprisonment by confinement, detention, commitment, restraint for whatever cause or under whatever pretense. That's why. Okay, so that's pretty much habeas. That's all I want to cover with that. Let's go to the next one. Chapter 3, Certiorari. The office of the writ of certiorari is to correct errors of a judicial character of inferior courts. Now, this is usually what you find when people are filing their appeal, if you will, to the Supreme Court. It's usually always done by a cert, and that's just how they abbreviate the name. They call it, filing a cert. So what you're doing is you're saying, hey, the state court erred. Hey, Supreme Court, help me out. They weren't doing what they were supposed to be doing, right? Okay, so is to correct errors of a judicial character of inferior courts and errors in the determination of special tribunals, commissioners, magistrates, and officers exercising judicial powers affecting the property or rights of a citizen and who act in a summary way or in a new way not known to the common law. So get that, right? And also in the proceedings of municipal corporations in certain cases. The Supreme Court has jurisdiction to reward a certiorari even where the law has provided some other tribunal to hear and determine the questions, if the jurisdiction is not taken away by express words. The acts of officers of municipal corporations, if plainly judicial in their character, may be reviewed on certiorari. So, the determination of an appeal from the commissioners of highways, so the decision of an officer to whom an application for habeas corpus is made, that he has no jurisdiction to grant it. So where an officer discharged a complaint under the act to abolish imprisonment for debt on the ground of want of proof. So in proceedings in insolvency and court martial. That's interesting. I didn't know you could do a cert against military tribunals, but okay, I guess you can. So as to the determination of canal appraisers, where it is alleged they acted without notice, so on and so forth, right? I'm not going to read all the rest of that. Okay, so the granting of a certiorari is in the discretion of the court, and it is often denied where the power to issue it is unquestionable and where there is apparent error in the proceedings below. It is said in a recent case in the Court of Appeals, quote, an order which simply quashes a common law certiorari has often been held not appealable to this court because the issuing of the writ rests in the discretion of the court, and consequently, it can, in its discretion, recall or squash the writ without passing on the validity of the proceedings sought to be reviewed. Before allowing or acting upon the writ, the court should be satisfied that it is essential to prevent some substantial injury to the applicant, and that the mere object aimed at by him would not, if accomplished, be productive of great inconvenience or injustice. Okay, so there's something I want to make a point here. When they keep talking about is in the discretion of the court. Okay, is in the discretion of the court. I'm just going to highlight because that's very important. Okay, so you have two types of appeals or two types of these aspects of high prerogative writs. One is by discretion, which is what they were just talking about. Court doesn't want to allow it. Court says, nah, we don't want to entertain that. They don't have to. It's by discretion. The other is by right, which is what we were just reading regarding habeas corpus. Habeas corpus is a writ by right. They have to take it. There's no discretion there. Okay? So, just understand that you have appeals by discretion and you have appeals by right, as far as the court deciding what they can do or not do, okay? So, so I think that's all I want to say on cert. Let's go down and get to the fun one for the evening, which will be Quo Warranto. The action of Quo Warranto. The writ of Quo Warranto and proceedings by information in the nature of Quo Warranto. Oh, and proceedings by information in the nature of Quo. I didn't know you could do a Quo Warranto by information. Huh. Okay, another thing I just learned. Have been abolished. Okay, no wonder I didn't learn about it. All right. The relief formally obtained by means of either of these writs may be obtained by action where an appropriate action, therefore, is prescribed in this act. An examination of the provisions of the statute under which the former proceedings were had by information in the nature of Quo Warranto, and the provisions of the code by which a civil action is substituted as a means of attaining the same remedies will show that the former proceeding by information and the latter by action are substantially the same. Almost every provision of the code is reenactment of the same or similar provisions of the statute. Consequently, the practice under the code will differ from that under the statute only as practice in civil actions may differ from that in special proceedings. Okay, now, why is any of that important? Why is that whole bit of little history here relevant at all? Okay, you got to remember when this thing was written. Okay, this is pre-1900. So what you're seeing right here in this little paragraph is you're seeing where they're starting to move things away from common law and into what they call code pleading, which is now what we're having to deal with all over the place, which is basically an aspect of Roman civil law controlment under various different statutes to say, oh, this is how we're going to do this now. Well, tough shit. As far as the common law right to do these things, that does not change. So that's why, again, I wanted to emphasize the fact that you never, ever want to use a statute to state your authority, basically your judicial clause, if you will, to state why you have the right to do something. You never want to use a statute to do that. But in this little thing that they're just talking about here, how they got rid of the proceedings by information, well, that was done by some statute that they had in place, and now they're gonna the provisions of the code by which the civil action is sustained as a means of attaining the same remedies. So now they're just gonna say, yep, just do it by a civil action, or it's just gonna be revert back to what it should be, which is an at-law high prerogative writ. Okay, so this didn't really give a good example yet as to what it actually is. Okay, well, anyway, let's continue. Against corporations, the Attorney General, whenever he is so directed by the legislature, must bring an action against a corporation created by or under the laws of the state to procure a judgment vacating or annulling the act of incorporation or any act renewing the corporation or continuing its corporate existence upon the ground that the act was procured upon a fraudulent suggestion or the concealment of a material fact made by or with the knowledge and consent of any of the persons incorporated. And that's rather interesting. That means that not that they do it, but that we could drop writs of Quo Warranto onto the Attorney General's desk to, say, pull the charter of Monsanto. Sounds like what that's talking about. All right, to continue. Or the Attorney General may bring the like action on leave granted for that purpose by the court or for purpose of vacating the charter or annulling the existence of a corporation upon the ground that such corporation has either, one, offended against any provision of an act by or under which it were created, altered or renewed, or an act amending the same and applicable to the corporation. Okay, fine. That's dealing with corporate charter. Two, when it shall have violated any provision of law, well, okay, there's the big one, whereby it shall have forfeited its charter or become liable to be dissolved by abuse of its powers. Right there. Okay. All right. Now, I brought up Monsanto. That was just kind of a off-the-cuff thing. But what are all these courts? All these courts are private for-profit corporations. They do not share purses with the state, which means they have no 11th Amendment immunity, which means technically, if we really wanted to, we could drop writ of Quo Warranto on the Attorney General's desk and say, get rid of these private for-profit courts. Because why? Because by any provision of law, meaning that they are violating law by operating private for-profit courts, which, by the way, is a crime. It's called barratry. If you're making money off of the law, that's called barratry, and that is unlawful. What are they doing? Exactly that. So this is an interesting thing. I might have to come back to this and think about this some more, as far as about what to be able to take down the charterability of a private for-profit court through a writ of Quo Warranto. Okay. All right. 3, whenever it shall be have forfeited its privileges or franchises by failure to exercise its power. Okay, that just means it's basically not doing anything. 4, whenever it shall have done or omitted any act which amounts to a surrender of its corporate rights, privileges, or franchises. Okay, that's kind of like 2. 5, whenever it shall have exercised a franchise or privilege not conferred upon it by law. Now, that I'm sure that applies to a lot of corporations. And it is made the duty of the Attorney General, whenever he has good reason to believe that any of these acts and omissions can be established by proof, to apply for such leave, and upon leave being granted, to bring such action in every case of public interest and also in every other case where satisfactory security for costs and expenses shall be given. Actions of this character must be brought by the Attorney General in the name of the people of the state. Now, I wonder if they could be brought in the name of a private Attorney General. Because you can do that. You can bring actions as private Attorney General. I wonder if that's possible. Oh, another one. One of these things we can think about later. Leave how obtained. Leave to bring the action is granted upon the application for Attorney General. The court in its decision directs notice of such application to be given to the corporation or its officers. Okay, fine. It is said in a recent case the Attorney General may, under sections such and such, make an ex parte application for leave to bring an action against a corporation, but it is within the power of the court to direct that notice of the application be given to the proposed defendant. Yeah, okay, that makes sense. Yeah, there's a lot of people that have done private AG, Viper. When the application, and I actually found a lot of the history on it. I was thinking about doing a case on it, or not a case, but a class in sometime in the future, because the whole private Attorney General, I thought for a long thing was something that was people were kind of like making up, but then I did actually find the law for it. I'm going, oh, okay, so it is a real thing, and you can do it. And the funny thing is now, I've been reading a lot of, and I'm not trying to digress here. This is getting to the point. I've been reading a lot of user and license agreements recently for software, just kind of for fun, and seeing if I can't strengthen some of the docs regarding the arbitration clauses. And in almost every single one I've read recently, it's yes, anyone can become private AG as far as I understand it. It said in all of these user and license agreements that you waive all of these various different types of suit, including but not limited to suits by private Attorney General. And I'm like, oh, they're even putting it into user and license agreements now, because obviously people have woken up and realized that you can do this. But anyway, okay, so private Attorney General thing aside. All right, to continue. Where the application is, this still really isn't giving me a proper definition of Quo Warranto, which is what I really kind of wanted to look up here. I'm looking for a general definition of Quo Warranto, and it's really not in here, or at least in the beginning, like it was in the rest of them. Anybody want to just like really quick, just find like some generic definition of Quo Warranto? Or actually, you know what? Somebody do me a favor. Pull up Quo Warranto in Bouvier's Law Dictionary and let's read that. Let's see what the actual definition it is out of Bouvier's. Because as fascinating as reading this section of this treatise is about what you can do with Quo Warranto, it's not giving a definitive, real answer as to just a plain definition as to what a writ of Quo Warranto is. And that was really kind of what I was searching for, or what I wanted to read in the beginning of this. So if someone could do that, that'd be great. Let's take a look now at the writ of Quo Warranto that Viper sent me. Somebody was going after a whole slew of idiots in D.C. Not for so much not having oaths and bonds, but apparently there's some other issue here regarding what they're supposed to be doing. So I'll get into reading this, and at the same time, I'll pull up the one that I'm working on for Viper, so you guys can get a good side-by-side. This was what Viper sent me. So U.S. Attorney's Office, District of Columbia, and this is just the petitioner. On petition for writ of Quo Warranto, the U.S. Attorney General in the District of Columbia, right? So this is in D.C. This is within the corporate jurisdiction. Director of the Center of Disease Control and Toxic Substances and Disease Registry, Rochelle whoever. U.S. Secretary of the Treasury, Janet Yellen. U.S. Secretary of Energy, Jennifer Granholm. FDA's Principal Deputy Commissioner. I'm not going to read the names. I'm just going to list the offices. U.S. Secretary of Health and Human Services. U.S. Secretary of Transportation. Secretary of State. Secretary of Department of Homeland Security. Secretary of Education. Secretary of Commerce. Attorney General. And Commissioner of Food and Drug Administration. Secretary of Labor. Deputy Secretary of Labor. Secretary of Defense. And Vice President Gobbleum Harris. Petition for writ of Quo Warranto, submitted by so-and-so and law firms, yada, yada, attorneys for petitioner. Jurisdictional statement. And so this is how I have this laid out the same for Viper. But I said in and for the Supreme Court of Florida. Here it says just petition for writ of Quo Warranto. I don't want to make this a petition per se. I want to just say, hey, issue it, right? We, the people, are going to wish that this writ be issued from the Supreme Court of Florida to go after the long list of people who Viper will put right in here. So on petition for writ of Quo Warranto to the Supreme Court of Florida regarding, and like the long list of names here, exactly, I did the same thing, right? Is saying, okay, name all of the judges, DAs, and others who have no oath or bond filed onto public record. This will be what Viper has to basically fill in. So, petition for writ, petition for an absolute and this is all in caps, for whatever reason, I don't know. But so, petition for an absolute extraordinary high prerogative writ of quo warranto. What's absolute? Means it comes from the king. What's extraordinary? Means it comes from the highest court. High prerogative, meaning just simply that we felt like it. And then what the writ is. Signed, sealed, and filed by the people of Florida. Because at the end of this writ, we're going to have a place where like 50 or 60 or even more people that are all people of Florida can sign off and seal this, particularly if they already have their house seals done. Sign and seal it. And then we'll send it into the court and we will CC it to all of the list of idiots that are in here, whatever that may end up being. And I said, petitioner is one of the people of Florida, as are all of those who have signed and sealed this writ. So then we get into jurisdictional statement. On this side, the federal corporate side, the U.S. attorney has jurisdiction over this petition pursuant to 28 U.S. Code, subsection 1651, and D.C. codes, yada, 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 as it seeks a writ of quo warranto from the Federal District Court of the District of Washington, D.C., regarding individuals elected or appointed to an office of honor or profit in the civil or uniformed services. All conditions precedent are satisfied, waived, or otherwise deemed unnecessary to instigate this action. And what I wrote for Vipers is this. Supreme Court of Florida, established by the first Constitution of Florida in, name the year of the Constitution, under section, name the section that established the Florida Supreme Court, hereinafter court, has original jurisdiction over the issuance of this absolute extraordinary high prerogative writ of quo warranto, hereinafter writ, and it is the wish of the people of Florida. That's basically saying right there. And it is the wish of the people of Florida right there. That's the command of we the people to the Supreme Court of Florida saying, issue this thing. Because what do sovereigns do? They don't order people around. They wish for things. They wish for things to be done. And if that sounds goofy, too bad. Because it's an ancient practice within courts. The king never demands anything. He says he wishes for this. I wish for this to be done. I wish for that to be done. Right? And it's the wish of the people of Florida that the said Supreme Court issue the said writ forthwith and without delay from the date of this filing. This writ is in regards to certain individuals elected or appointed to an office of honor or profit that are required by law to file a valid sworn oath of office and bond pertaining to their office before they take on the duties of said offices. All conditions precedent are satisfied, waived, or otherwise deemed unnecessary in order for this writ to issue. So I guess where I stole that from, right out of here. Next section. Relief sought. Pursuant to petitioner McGee respectfully petitions the U.S. attorney for a writ of quo warranto regarding the legitimacy of authority of the following persons. And then this long list of persons again, which I won't reread down here, and collectively appointees. So what will Viper do? Pursuant to, and this is why it's in red, because this won't apply. This is the federal thing that I put in here, but I'm just putting it in red as a placeholder. So pursuant to, so what are we going to put in here? Any sort of law that comes from any foundational document that deals with high prerogative writs. Okay? Anything of the common law, anywhere that we can find that says, yes, we have the right to do this. And that might be short, it might be long, I don't know yet, but we'll have to piece it together and put it in here. I would highly suggest to anyone who wants to create a writ of this sort, including but not limited to Viper, get onto your state Supreme Court websites and start just searching for high prerogative writs. Whatever you want to file, whatever you want to put together, find a template for that writ and then tweak it how I'm tweaking it in here. Now, of course, this is federal to state. So again, there's going to be a lot of changes between the two, but this is the only thing that Viper sent me. So this is what I was working off of, and it's fine. We'll use it as an outline to do what we need to do. But if you're using state law or going after state public officials, then use aspects of the foundational documents of your state. Use public law. Always follow public law, not fucking public policy. Okay. Public law. There's a huge difference. Okay, so pursuant to, and this will change, petitioners, the listed people of Florida, hereinafter people, wishes that the court now issue this writ regarding the legitimacy of authority of the following persons: Assistant Attorney General for the state of Florida, who I forget their name because obviously that isn't their name, but Viper knows who it is. District court judge of whoever district, and that might be the wrong district. I'm just keeping these in here as placeholders. And so hereinafter dipshit, attorney general, Ben Bad, hereinafter bad, collectively appointees, right? Same as this. Just copy and pasting, more or less doing the same thing here. For those individuals who have failed or refused to produce a valid oath of office and have failed to file a proper bond as per public law, name the law or constitutional clause. So we'll fix this. And we might even alter this a little bit instead of just per public law, I might just say as per valid law, whatever. And then comma, demand that those persons provide the people, meaning whoever's going to sign this writ, and this court, meaning the Supreme Court of Florida, with the compulsory oath and bond within 10 days. See, same thing as it said here. And the same thing that it said in the writ, right? Or the treatise, sorry. Regarding the 10 days. So why it's in here. So, and then 3, or actually, I'll read this one, the federal one. For those individuals who have failed to or refused to produce an affidavit as required by such and such code. And by the way, I popped this code today because I was just kind of curious what the hell they were going after. So what they're going after on the other writ is officer affidavit, no consideration paid for appointment. An officer within 30 days after the effective date of his appointment shall file with the oath of office required by section 3331 of this title, an affidavit that neither he nor anyone acting in his behalf has given, transferred, promised, or paid any consideration for or in the expectation of hoping to receive assistance in securing the appointment. I think that specifically is going to apply to Kamala Harris, but let's just make it apply to everybody anyway. So there's this weird affidavit that these people listed in the said writ have to do above and beyond just simply having the oath and the bond. Now, all Viper's doing is just going after the fact that, hey, idiots, you guys don't have oaths and bonds. So that's the problem that Viper's finding in Florida, is that he did, well, okay, I'll get to what he did in a minute. All right, so that's that side. No, this side. Number 3, for those individuals who do not produce the valid oath of office. Okay, well, let's read the federal one side first. For those individuals who do not produce the affidavit within 10 days as described above, as well as those who have admitted they do not possess the required affidavit, and those who have produced defective affidavits, because all of that's going to apply over here too. A, immediately terminate their appointments or positions. B, render all official acts, bills, laws, regulations, or any official actions whatsoever, including the appointment of any subordinates, void ab initio, right? That's the important thing, because that's what Viper wants to do. He wants to get rid of his court case. How do you do that? Well, you go after the idiot that doesn't have an oath and bond. What are you doing? You never had the capacity. You never had the authority to ever hear the case to begin with. So, void it. C, replace and restore all proper former office holders until competent replacements can be lawfully appointed. I think this one's kind of interesting. Okay, so what did I say over here? Basically the same thing, but I'm gonna alter this a little bit, and I think this is about to the point where I got to the copy and paste today. So the rest of this will be like issues presented I haven't gotten to, even though I'll cover it here in a minute. So what I said for the individuals who do not produce the valid oath of office and bond within 10 days as described above, as well as those have admitted they do not possess the required oath and bond, and those who have produced defective oaths and or bonds, because Viper has found defective oaths. A, immediately terminate their appointments and positions. This is basically all verbatim what the other side said. Render all official acts, so on and so forth, void ab initio. Replace and restore all proper former offices until competent replacements can be lawfully held. And I need to fix that thing right there. Okay. And then this other thing was just a writ of Quo Warranto that Viper grabbed from somebody else a while back, and was an interesting attempt at creating a writ of Quo Warranto, but it needs a lot of work. But there's some things in there that I'll probably pull, like there's some law out of it. So I'm keeping that below, keeping this to the side. So this is what you do when you start to create a writ. You have to go through this. Now, granted, this bloody thing's 100 pages. I'm not going to try and obviously recopy everything of 100 pages from here over to here. That's completely unnecessary. But issues presented. U.S. Code, oath of office states. And so this is where Viper will put in the law, the public law that says that they're supposed to have such and such oath. It'll state what they're supposed to do. La, 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 so help me God, period. Concordantly, this officer affidavit, no consideration paid for appointment states, blah, blah, blah. So we'll have the oath here. What they're supposed to do is state officers, yes, get your oath in properly. And this is the law that says you're supposed to do it. And this is then the law that'll say what that you're supposed to post your bond, right? And where you're supposed to post both of these things. Because also, I don't give a damn if somebody maybe did an oath and bond, but they have it in their closet. That's not official. Okay. 6. In order for any affidavit, including an affidavit in support of a person's oath of office, it must be sworn, to which include specific provisions requiring allegiance to the nation and office they hold in support of the nation, which contains, inter alia, the following language from the form appointment affidavit, which states in relevant part. So this is what the thing that they're getting after in the federal side regarding, hey, you didn't do your affidavit right. In order for it to be effective, sworn declaration must either be sworn before a notary public or sworn under penalty of perjury. Which requires, and this is something that will definitely, this is something definitely Viper will throw in, something like this, because it'll say, yes, you're supposed to do this as per state law. And then 8, the issue before the U.S. Attorney General, and it'll say the issue before the Florida Supreme Court is straightforward. Petitioner has sought to require affidavits prescribed. Petitioner has sought to require valid oaths and bonds for all appointees referenced via the Freedom of Information Act request. Again, Viper will say the verbatim of this, but it won't be FOIL, it'll be state open records request. And not one of the aforesaid appointees has produced a complaint affidavit consistent with the applicable statutes. Vipers will say that no one of the aforesaid appointees have produced a valid oath and bond as per the applicable public law, right? Either the affidavits were non-existent, wanting, defective, or the appointee has failed or refuses to provide the mandated affidavit to hold their respective offices. And I'm just going to pause here for a moment and make a point about this as far as what they're doing on this federal writ. Everybody in the swamp is just taking money from basically the corporatocracy, either the Khazarian mob, bankers, any other corporations, whatever, right? They're taking money. They're never saying that they're doing it, or they're even taking money from, I would say, foreign princes or principalities or foreign agents or those that are directly guilty of treason, like, I don't know, let's say George Soros, right? So it doesn't surprise me that none of them are going to file this affidavit because they're all taking the money. Because if you don't follow the law and go along with it, well, then, okay, the law can't be used against you, to go after you for violation of the law if you never, did what you were supposed to do from the beginning. A really good example of this, or probably maybe the most famous case about this, would be the case of Benedict Arnold. Sorry, didn't sign it. Fuck you. Have a nice day. Anyway, if you guys have no idea what I'm talking about, you should go look that up because it's a very interesting case about the court-martial. 9, 5 U.S. Code is non-discretionary and mandatory. Right, so we'll make sure that we state that. Yet none of the aforementioned appointees have complied with or fulfilled the oath/obligation to hold their respective offices or appointments. For the reasons provided, petitioner respectfully requests the U.S. Attorney seek the court to issue a writ of Quo Warranto and enforce the relief sought in Part 2 for the individuals referenced, as legitimacy of each to hold their respective positions or offices are demonstrably in question. That's a very good way to put that. I think I will probably steal that too. And then statements of fact. And this is probably where this thing gets so bloody long, because it'll also probably be fairly long for Viper as well, because he'll have to put this in. Section 4, statements of facts. So, Center for Disease Control. On February whatever, petitioner submitted a FOIA requesting a signed copy of Director of the Center for Disease Control, Rochelle P. Walensky, oath of office, period. Petitioner received a response, which included an incomplete copy of Walensky's oath of office. No surprise there. See Exhibit A for a composite of all communication exchanges along with the defective affidavit oath of office. Okay, so this is the same thing that Viper will do, except he will have to name each and every idiot that he went after, that he did his state open records request for, and that came back either defective or non-existent. And he will put that in as this one. Go after first judge. First judge stuff will be Exhibit A. Second judge stuff will be Exhibit B. Third judge stuff will be Exhibit C. Fourth judge stuff will be Exhibit D. Fifth, right? You get the point? You're just going to do this over and over and over. You just have to repeat it so that you're putting in all your facts. And that's all this is. It's the facts are what each single one that Viper's going after does not have an oath or bond or both. What he did to demand the same, and the reply back as to what didn't happen. And Viper's actually been showing me a lot of these on Mega. But this is what he'll have to do. So you'll get through this. So these will be all of the facts. Actually, I haven't even gotten down to the next section, whatever it may be. Oh, okay, summations. Summation and summary of the foregoing, and for ease of reference per below, petitioner sought the production of the compulsory affidavits that evidence of each officer's allegiance to the Constitution and commitment of all official acts conducted by them could potentially subject them to treason. Hello. For failure of adherence. Right. Can you commit treason against the state? The answer is yes. So, the FOIA responses or lack thereof are listed below, categorized by their noncompliance or defects. Oh, okay, perfect. So, Viper, yeah, if you want to create a little sort of timeline like this, I guess it's not a timeline. I guess it's just kind of like a little layout. That'd be great. So just, so-and-so failed to respond. So-and-so failed to respond. So-so didn't have it, whatever. Came back defective, la, 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 la. Okay. Defective affidavit, received letter. Okay, so yep, that's just more information. Okay, reasons the writ should issue. Right, and this is a section that you should always put in any high prerogative writ. Basically, this is where you make your argument as to why the court should do what you're telling them to do. A petition for quo warranto is an appropriate method for determining whether a person is eligible to the office or position to which the individual was appointed or elected. Okay, actually, that's the best definition that I could find. Did anybody actually put that into chat? I didn't look after I asked somebody to grab it. Yeah, okay, so... All right, Amaru did from Bouvier's quo warranto. Okay, so let's put these next to each other, because these seem to be the court holdings. So let's see what the court holdings say in relation to the definition. All right, so let's see what the definition says. Quo warranto, in practice, the name of a writ and also of the whole pleading by which the government commences an action to recover an office or franchise from the person or corporation in possession of it. Oh, so it's actually shit. Okay. Then that makes me wonder if we can... Well, hold on. The people are above the government. No, we're demanding that the Supreme Court do it. So, it'd still be the government doing it. But can the Supreme Court...
I wanted to interject here real quick. The first thing that jumps out to mind is we're talking to the Supreme Court, and they don't have valid oaths of office either. So why are we petitioning the Supreme Court of the state of Florida?
Well, then there might only be one person... If I'm, we're reading this correctly, and I'm not going to make it into something it's not, because this is what it is. It might just need to be a different high prerogative writ is all I'm maybe getting at here. Because, okay, so the name of a writ also by which the government commences an action to recover an office or franchise from person or corporation in possession of it. I'm wondering if maybe that's why none of them have valid oaths of office, for the exception of... Wait, did you actually find out if the actual Attorney General did have one? I know the assistant didn't.
Yeah, I've got Ashley Moody's oath of office. It's fake. It's de facto.
Oh, it's not. Okay, it's de facto. It's not proper. Oh, okay, it's not proper. Fuck. God. Well, no one has one. All right. Well, then
that's the point. That's the whole point about.
Okay. All right. Then I'll just okay. Fine. Then I'll just have to write this in a way, but you could kind of already see that I sort of wrote it in this way anyway. I'm just going to have to write this in a way that we, the people, are just doing it on our own sovereign authority.
If no one in the government of Florida has a valid oath of office, if no one of the proper authority in the state of Florida has their bullshit, basically, according to law,
right,
then that would be a case where this could actually be submitted directly to the Supreme Court of the United States.
That's true.
And basically, waving our hands, screaming.
Yeah, you know what
everything here is jacked up.
That's right.
And you need to come and fix this before we fix it ourselves.
Yeah, because the other thing it could be sent to too, it could be an argument to be taken directly to... It could be taken directly to the provost marshal and saying, this is an entire insurrection of the state of Florida. Military assistance needs to act immediately. And demand,
that's exactly what we're trying to get at,
and demand that they bring it in. Oh yeah. Okay. Sorry. That's a good point. I didn't even get to that yet. Well, I will get to it because this brings it up.
The other part with what he just said is a critical component of it, because if you look in Article 1 of the Constitution back in 1789, there is another caveat to this. One of the subsections in there talks about a writ of elections. So you could literally combine this writ of Quo Warranto with a writ of elections, force them to get out of office, and then have somebody with a valid oath, whether it's the military AG, or excuse me, whether it's the military JAG or provost marshal, or somebody come in and have the new people take
Wouldn't
a
that be
valid
fascinating
oath.
if the military literally took martial law over Florida because of this? That would be funny. That would really be funny.
Exactly.
Especially with all of the people that have been leaving to try to be like, I don't want to go to Florida where things are sane.
Yeah. The other crazy thing about this too is if that did happen, let's say it went that direction, you know that all courts are considered commissioned courts under the DoD Law of War Manual. So technically, they could all face a court martial, and they could all be sent to Gitmo. I'm dead serious. They could all be sent to Gitmo for it.
Well, I would actually argue the problem with that is a big part of the. So I knew dudes when I was in that were getting out at like 18 years. Okay. 18 years. You can retire at 20. 18 years. They're getting out. And I was just like, dude, why? Seriously. Like, what is so bad that you're not willing to do another 2 years? You know, and I'm thinking some kind of extreme family situation. They were like, no, it's just gone that far downhill. I can have no more of this. And that's seriously the way the military has been.
Yeah, that could be. I mean, as far as the military is concerned, they probably, if there's that many people that have already left that have already gotten sick of it, those would probably have been all of the people that would be willing to do something like this properly.
The military is entirely full of furries and faggots. I shit you not.
Yeah, so that's probably not going to happen that way. Yeah. But let's read the rest of this. I'm going to go back and forth and finish my thought here as far as the definition is concerned, just so we can get all this out. Okay, so writ commands the sheriff to summon the defendant to appear before the court, which is returnable, to show quo warranto, by what authority he claims the office or franchise. See, now this is actually going back, well, that says 1928. Well, this is still the way that it would have been done at law, though, at common law, that the sheriff would send it out. And then, okay, so it is a writ of right. Well, what the fuck then? Why was it talking about it being discretionary in the treatise? All right, whatever. A civil remedy to try the mere right of the franchise or office where a person in possession never had a right to it or has forfeited by neglect or abuse. Okay, so it's a writ of right then. Fuck it. The action of quo warranto was prescribed by the statute of Gloucester 8 Edward. Oh, that'd be an interesting thing to go read. I always like to see the original creations of these things. And I, as assimilation upon the royal prerogative, before this institute, the king, by virtue of his prerogative, sent commission over the kingdom to inquire to the right of all franchise, quo G, quo nome, il retente, etc. And they were grants from the crown. If those in possession of them could not show a charter, the franchises were seized into the king's hands without any judicial proceeding. Okay, makes sense. Like all the original civil writs, the writ of quo warranto issued out of chancery and was returnable alternatively before the king's bench or justices in Erie. Okay, fine, interesting. Writ of quo warranto has given place to information in the nature of quo warranto. Yeah, okay, but this got rid of the thing that we read in the treatise, so whatever. Leave file information. Okay, still under information, so they don't do that anymore. If the proceeding referred to usurpation of the franchise municipal corporation, the right to file, file the information, is in the state at the discretion of the Attorney General. Yeah, again, it gets back to the Attorney General. But no, we got to do it as a whole body of the people. Individuals cannot take proceedings to dissolve a corporation, but in regard to the election of corporate officer, again, that might pertain to the court, but whatever. In Pennsylvania, it was held that a stockholder whose votes were strongly rejected by corporate, don't care about that. And the court will discern granting the writ. Leave is granted on a petition or motion with affidavits upon which a rule to show cause is granted. Yeah, because they got to show cause. Because they have the right to defend. The writ lies against the corporate body if it is to restrain or usurpation or enforce or forfeiture. But if it is to inquire whether a corporation has been illegally organized, the writ lies against the individuals. Oh, that's interesting. Whether a corporation de facto is also one de jure can be determined upon only in quo warranto. Oh, fascinating. Okay. So, yeah. So basically, yeah, that's important. Whether a corporate de facto is also one de jure can be determined only in writ quo warranto. So, hey, fuckers, you're all running de facto courts here. All right, from Webster's 1828, writ from which that which is written in the census particularly applied to the scriptures of the books of the Old Testament. Okay, yep. From right, writ. In law precept issued from the proper authority to the sheriff, deputy, or other subordinate officer commanding him to perform. Okay, yeah, that's just a writ in general. All right, cool. Okay, now let's read what the case law says. So I'll reread this. A petition for quo warranto is an appropriate method for determining whether a person is eligible to the office or petition to which the individual was appointed or elected. Newman versus U.S. Next one. The purpose of bringing a writ of quo warranto is to correct an improper appointment or election and ultimately to achieve the ouster of the person who is illegally occupying a public office. Also a good one. If these are like Supreme Court cases, if they went to the Supreme Court, we could still use them, Viper. So just making, you know what? I'm just going to make a note of that. Just going to highlight it. Stated differently, it is used to question the authority of an individual asserting a right or title to a public office or appointment and intended to prevent or challenge the exercise of those powers that are not conferred by law. Again, another good one. These are all good. Wow, okay. You just steal all that straight out. All right. The United States Constitution is clear. And of course, I would state the Constitution for the United States of America is clear that no person shall be senator, representative in Congress, or elector, or vice president, or hold any office, civil or military, under the United States, or under any state, who, having previously taken an oath, as a member of Congress, or as an officer of the United States, or as a member of any state legislature, or as any executive or judicial officer of any state, to support the Constitution of the United States, that should be the Constitution for the United States of America, but whatever, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof, which I think can probably be argued also, particularly in this case, when it seems to be the whole fucking state. It's just insane. Now I'm really starting to see what you're talking about, Viper, by the way, about how insane this is getting. It's literally like the entire state doesn't have one. U.S. Constitution Amendment, what is that, 24? This necessarily implies that oaths must be taken as required per code. Okay, fine. And per code. Okay, fine. This would be the state. We're going to hit the state public law with this one. Okay. Now we pretty much know what it is. And the other thing I was thinking about regarding possible military action or things of, other things we could bring in, considering it is bloody like the whole entire state of Florida, is an aspect of the Coast Guard. And this all being basically under the jurisdiction of inland piracy. Inland piracy is definitely something that they're doing in every single court. Not only is it inland piracy, but it's also human trafficking, which then gets into the executive order 13848, which I will put into chat. 13848 was the executive order that Trump put in regarding that if you're found guilty of human trafficking, all of your assets are forfeited. Well, what is a court but other than doing human trafficking? That's exactly what they're doing. So, and by the way, Biden actually extended, strangely enough, this executive order, which I don't know why he'd do such a thing, but he did. So there's two other options or two other things that we could also bring in for what we could do here with this writ. I think another thing with this writ should be put in, added that, actually I'll make a note of this as well because I haven't written this down yet for the writ, that what I also want to add into the authority, if you will, or the remedy part, is that under the DOD Law of War Manual, because none of these people are properly showing their colors, that they're on the other side, meaning like they're on the enemy side, technically they can all be treated as spies and shot immediately. Now, that would be the preferable remedy as far as I'm concerned, because they're operating for foreign prince or principality or foreign government, or even operating by under agencies that are specifically the enemies of the people, like George Soros and others. Well, and if you're not saying, hey, I'm on this other side over here, you're not showing your color, as it were, then under the DOD Law of War Manual, you're considered a spy, and spies can be shot. So, yeah, there's that whole part of it too. So, does anybody have any questions or anything else they want to bring up? Because we're actually getting past an hour here, but that's pretty much everything I wanted to cover tonight.
Yeah, I
Well,
found
let's
in
put that.
Indiana they're using it today anyway under their code to oust, and it literally says, I think it's a de facto, it oust other public servants or bad actors or whatever you want to call them. They're using it to oust each other with the writ of Quo Warranto.
Oh, they're using it against each other. Well, that would make sense. I mean, from the standpoint that it's kind of supposed to be given to, I mean, it's supposed to be like the government that's supposed to do it. So if you got one party, see, this could be used as lawfare, which I'm guessing is probably how it's being used based upon what you just said. But I mean, I don't want to make any conjecture here. But if it's something that's done by the government and then they want to go after their political opponents, well, yeah, that's one way to do it. So I could see him doing that.
It has it in code, but I didn't want to post code when you're trying to keep it common law. But
well, it's okay. I mean, you can post code as far as just the interest to seeing the two different sides of the system. I mean, that's fine. We should always study every single aspect of law that we can. We just need to know that, hey, this is that, that's this, that's a monkey, that's a gorilla, that's an alligator. You know, don't mix them. You know, kind of thing.
But according to their code, you're supposed to, if there's a de facto actor, then you're supposed to notify the commissioner, and the commissioner is supposed to notify the attorney general, and he's the one that brings a writ of quo warranto against the bad actor and oust him.
Yeah, but in this situation, none of them have the people that are supposed to be doing this. Those de jure offices are in fact vacant, and that's where it comes into not only having this quo warranto from the people going, if you don't step down, going to the military and you face charges of treason.
Maybe we should just put the remedy. Oh, fuck it. Maybe we should just put the remedy in that we're going to convene a 25-member grand jury and try them for treason. How about that? That's the easiest thing to do, because then we're not dependent upon anybody else to do this but us.
Exactly.
Okay, that's what I'll put in.
The people are the government.
I'll put that in then, because that didn't even cross my mind until you just brought it up, because now I'm like, wait a second. Who's going to try them? Well, it's got to be a grand jury.
Exactly.
Yeah, I think the only way to solve this is the grand jury, because only with a grand jury can announce the grand jury proceedings are happening. We can publish this in the newspapers, in the proper state newspapers for announcement, meaning public fucking notice, saying, hey, we are doing this. Anyone who has any information can please come to the grand jury or submit the information to this location digitally or physically, right? The grand jury can take out a P.O. box for fucking months, couple months, whatever, because it's probably going to take a couple months to figure this all out anyway. And then everybody can give the information, and then they can come in and you can get testimony from all of these people that say, yeah, and by the way, they told me not to do this. Or, oh, I know this other guy that doesn't have one too, and he said that we're not supposed to do it because of XYZ. You will probably get people like that will show up in a grand jury hearing. And that's what you should do, because I think this is the only way that this totally gets done, because apparently there's, like you said, there's nobody here that can do it. Meaning there's nobody with a valid oath of office that's supposed to be doing this. So it is now simply come down to us to do it.
Well, this is why I was actually saying the Supreme Court, SCOTUS, because the SCOTUS is probably the last remnants of legitimate officers of our American government. I mean, everyone knows Biden is not in charge.
True.
Everyone knows.
We wouldn't need to go to the Supreme Court to deal with a state issue. However, if you want to start bringing some of these other things that we're talking about bringing in, and telling the federal Supreme Court, oh, by the way, if you don't do this, our last option is to convene a 25-member grand jury of the peerage and take everybody out, because this is what it's come to. So
we're going to call the militia.
Yep, we're going to call the militia and the grand jury. We're going to organize a militia and a grand jury and just be done with it. That's it. Everybody that's going to get summons to come and testify before the grand jury, they're going to show up. If they don't, the militia will come and get them. They'll drag their ass there. If they don't want to talk, they'll have a contempt put against them against the grand jury, and we'll throw them in jail. And the sheriff can hang on to them until they want to talk, which is exactly what happened in Hale versus Ingle. And that's never changed.
By the way, yeah, the sheriff doesn't have valid oath either.
Well, okay. Well, I don't know how we're gonna. We'll almost have to create our own damn jail. I don't know what's gonna happen with that.
and get this. The county board of commissioners in multiple counties do not even have an oath of office. They'll raise their right hand and get on video and take an oath, but there's nothing on file, and they're not bonded. This is from the records division. I walked right into the records division for the sheriff, and here's his oath. It was expired. It took them like several days. Like they totally came up with a new one, and they admitted right there on the spot that he's not bonded.
Okay. Yep.
I mean, honestly, this is uncovering things that are so bad. I really, I mean, I know I always jump to the extreme, but I seriously believe that it's like Golgotha, or there was another city where you literally had hung men, crucified men, every mile on the roads leading into the city. Every mile they put up dead bodies from criminals, and this is honestly where I think that we are.
Yeah, it doesn't. Yeah, I completely agree with you. I mean, Romans had no hesitation doing the same thing. Not that I'm with the Romans at all, but. And speaking of Romans, by the way, when you're talking about county commissioners, all of this really stems from the ideas that from Roman civil law that they want to be able to control everybody through corporation without ever having any accountability to the people whatsoever. That is the modus operandi. That is what they're doing. And they've been doing it for quite a long period of time. And if anybody doesn't want to, or anybody doesn't know that, just go watch my timeline class, which you can only find on Odyssey, by the way. And we are being run by Roman civil law again. We're totally being put into a situation where they're trying to totally take everything back over by Roman civil law, have absolutely no common law authority anywhere, because that's where they're, amenable to us. And yeah, it would appear clearly that we're already at this point, because I had no idea until Viper started giving me all these names and giving me this other petition, the federal one we've been reading tonight. Clearly, none of them have it either. Yeah, it's a plan to undermining and take over the legal system. Now, go ahead. That is exactly what it is. And it has been happening since Reconstruction. After the Civil War. It's been happening since Reconstruction.
That's an important part of this, is that if the states are subject to the authority of their bosses in D.C., and their bosses don't have any authority, then how can anybody, even with a fake oath, participate if the authority of their head honchos don't have it? It all falls apart. There's nobody has any authority.
That's true. And yeah, by the way, Judd, you're right. Polk County would be one of the few counties that sheriff would definitely follow what the people said. That guy's one of the few constitutional sheriffs who regularly educates people as to what the actual law is.
Polk County?
Polk County's
they just murdered somebody the other day in cold blood. Oh my God.
Well, that's okay. One bad apple, but I'm saying the sheriff there definitely knows the actual common law, because I've seen videos of him talking about various different things of what the right of people to do is, as far as self-defense and all this other stuff. And I'm sure if the people
that's the same guy that we were just talking about earlier this week. They're talking about that sovereign citizen. That's him. That's who you're talking about.
Yeah. He was.
You're saying not. Oh, I thought it was the guy that said, yeah, that one. I thought it was that one.
That's the Polk County sheriff.
Yeah,
that asshole.
So he does. So he says it on. So he says it on one side that people have the right to shoot somebody else, whatever. But then he goes and just flat out murders somebody else.
Exactly.
Oh, that's fucked up.
They're
Okay.
they're playing both sides of the same coin. That's just a total public PR stunt to get people to not want to pursue their claiming their estate and getting out of this shithole.
Well, that's probably true. And aside from the fact of, by the way, anybody that doesn't know, and I hope I don't get the stupid tagline that I did for the sovereignty class, which was hilarious, by the way, on YouTube, talking about, sovereign citizen thing. There is no such thing, obviously. And anybody that states that term has clearly just capitulated and swallowed whole cloth. The the stupidity from the Southern Poverty Law Center, which is the organization, the known communist organization that teaches cops and sheriffs that term. So, but anyway, okay.
The responding officer was a female, and she was basically the victim was a homeless one of the black Hebrew Israelite, the black Moor nationalists. But and the sheriff had a video that was going off about how, these are these sovereign citizens. These people think they don't have to follow our laws. Well, he found out the hard way. He doesn't have to follow our laws no more.
Oh, so they just flat out. Yeah, so he was protecting the stupid woman cop that just shot him. Yeah, okay.
I don't really remember they're not releasing the video camera footage. That's what it is.
Oh, well then fuck, nobody knows what happened.
And that sheriff is normally very, very good about releasing footage, which makes me think that, the female officer was probably in the wrong. Yeah, basically, dude was parked he was homeless and sleeping in his car in a public park, not bothering anyone, but it's alleged that there have been break-ins and basically people opening handles and shit. So she was just like, but regardless, it was a sort of situation where it was just like, hey, park's closed, like can't go here. And he says, okay, but she was demanding his ID and he was just like, no.
Yeah.
And she wouldn't let him go. So, and then he wound up, and then somebody else responded because, female cop. And so he shot him.
Great. Yeah, exactly. Yeah, that's why everybody should get body armor. Everybody should have sidearms at all times. And if you don't have one, don't go buy one.
You're going to go to sleep in your body armor? I mean,
build one. Well, I mean, aside from that, yeah. But, if I was homeless and I was living in my car, I would go to sleep in my body armor. Seriously. Fuck that shit. That's because that's straight crazy.
Yours is more comfortable than mine.
Yeah. But it probably can't take anywhere near the level of armament that yours can. Okay, anyway, we're starting to digress a little bit. Okay, so any other questions about Quo Warranto or about any other aspect of any high prerogative writ that anybody wants to bring up or talk about before we call it? Because now we're getting to be about an hour and a half here. Sorry, what was the quick question?
Well, somebody had mentioned earlier about SCOTUS. If this was presented to SCOTUS, I mean, obviously they're a higher authority over the court systems of the state. Surely there would be some measure of accountability to SCOTUS by the state.
There would be.
Supreme
Sure.
Courts.
Yeah.
Article 3 courts have some type of jurisdiction over them, right?
Yeah, they do. And
So-
the very fact that Florida isn't even operating as a republic right now based upon this would probably be the single most important thing that they'd want to take a look at and be like, what? Because you have to operate as a republic to be a member of the
all
union.
their authority is delegated to them by the Article 3 courts per the Constitution, if I recall.
You mean the Supreme Court? Are you talking about?
Their authority has been delegated to them by
Yes,
courts superior to them.
the federal courts. Yes, the federal courts under Article 3. Yes, not the state courts. The state courts have their own capacity and jurisdiction to operate under the original state constitutions. But because they're not following them,
a writ of Quo Warranto be sent to those superior Supreme Courts, and would they do anything about it?
Well, I think, yes, you could, as long as you worded it correctly, because you'd say, hey, Supreme Court, we have an entire state, an entire supposed member of the union here who is not acting as a member of the union. And because the state signed the contract, meaning the federal constitution, because the federal constitution is not something that we have anything to do with as far as we're not a party to it. We created the thing. The states decided to agree to it or not. They signed the compact together to do X, to vest a certain amount of their state power to the feds. And then the feds say, yep, this is what we're going to do to kind of a little bit here, control all of you. But now they've pretty much controlled everything through commerce. But again, I don't want to digress down another subject. Yes, SCOTUS would definitely have say so, because this is an aspect of them not following the compact. It's almost in a weird sense like secession by stupidity.
Well, here
it would seem like the course of prudence would be to go up the chain of command. Like, if that's what their job is, then we need to hold them accountable and make them do their job.
Yeah,
if they don't,
right.
If SCOTUS doesn't do their job,
SCOTUS doesn't do it, then
now we got a really big problem.
Then it's only the militia and the grand jury. That's it. That's all.
Exactly.
That's what I was saying when I was saying like SCOTUS is basically the last vestige of the actual United States that we know should be for a fact in its proper place and position with everything taken care of, because everything else is subject. And honestly, I guess my real question would be, what do we do when no one is willing to do this? Because, I was hearing from some other news that they're talking like by 2025, all of the banks in the United States are going to go from SWIFT system to CBDCs, which that's it. That's the end. At that point, they would have total control, total visibility. The all-seeing eye of the Masons would be there because they could see every last $1.61 you spent.
Yeah, so it's a good idea to start getting our wheels underneath us is how to ride this bike before we have to actually start to ride the bike over some really tough fucking trails like the one you just mentioned. Because we can do it. It's not that difficult. It's not like this hasn't been done before. Plus, I got all the information in the world about grand juries and how to operate them. It's just a matter of protection and a matter of teaching people what we're doing and being like, nope. And if you try and physically come after the grand jury, that's it. That's war. Fuck you. That is war. No hesitation. No nothing. You die. That's it. So, but. Yeah, SCOTUS and then grand jury. That's what it's got to do.
And the other thing would be like, what do you do? I mean, when
call the coroner.
Because I agree. That's a very clear signal. This is war, but we still have the problem of 98% of the populace.
Well, I think you get to that point. There would be some contingencies I would definitely do. One, the first fucking thing I would do if it got to that point is that I would contact, to the best of my ability, all special forces in the area and say, look, I demand that you uphold your oath as to why Kennedy created your ass, because now's the time, motherfucker. It's now, right now. And then
all I got to do is walk into one of these VFW locations. And,
right. But the
special forces are all over the place, and they're fully armed and they're itching.
Kennedy created the special forces because he knew what he was up against, and surprise, surprise, look what happened to him. And he specifically stated in those charters that they were to not only arm but train the civilian population if the government ever fell or was taken over. That's their fucking duty. So, hey guys, about time here.
I was 3 blocks from their headquarters at Bragg.
So, right. So there you go. I mean, that's what they're tasked to do. So fine. Let's just, we got to go that way. I don't give a shit. It's kind of the way that everybody's been saying it's going to have to end up anyway. But at least it would be way better to be organized. Like, have really good organized, trained, good militias by the special forces. I'd be fine with that. I got no problem with that. As long as they're on the right side of history. So anyway,
if this is successful, and this Quo Warranto actually brings about some type of effect in Florida, that'll have a huge domino effect to the other states, possibly.
Yeah, I would.
This is really big.
Yeah, because I think
really
everybody's
big. I mean, I'm sure we've got it here in Missouri. So.
Yeah, I'm sure it's probably everywhere. I just didn't know to the extent of which it was until Viper started dropping all these names, and I'm like, what the fuck is going on?
So I've got to ask. This is I haven't actually asked this in the main chat, but those that are here in Florida, if you're willing to sign this writ when it's completed and ready, just send me a message or something, because I'm 50 names, at least 50. Oh, preferably more, but. We need residents or people that live in Florida.
Yeah, we need people of Florida to be able to sign and seal this thing. Yep, exactly. So, yeah, everybody that's one of the people of Florida, and if you're listening to this online later and you're not yet a member of the VSOF Gilded server and you'd like to be a part of this, join the VSOF Gilded server, get on the main chat, and, talk to Viper, and I'll have this writ done, probably not as fast as he wants me to, but I'll have it done. And we'll get this thing together, and then we'll need people from Florida to be able to sign it, because only people from Florida are going to have standing. Okay? So, and you got to be one of the people of Florida. You can't wander in here as a United States citizen demanding this. This is going to be 100% common law from the sovereignty of the people. So, and with that, let's conclude, because I know we've been going on for quite a long time here. So we're almost coming up on 2 hours. So with that, I think we all know what we got to do. As far as any other information is concerned, if anybody has anything else that they'd like to find or they do know about is regarding information of Quo Warranto, or if you find any other good written Quo Warrantos for the state side, particularly Florida, pass them on to Viper or myself, please, or both. And so we can use them as good templates and hopefully find some more good case law regarding specifically to Florida and or federal that will this pertain to.
Well, right, because we can apply this to any public office, whether it's the Board of Commissioners,
and then on right,
sheriff,
exactly,
the police.
Yep.
I mean, any police officer, like they pull guard duty or duty, whatever, at libraries or other locations, and you go up and ask them, hey, do you know about de facto versus de jure? They look at you like you got 3 nipples. It's like they have no clue, and they've never been trained, and they're
the average
like inside themselves.
Yeah, well, they're going to learn. So
the average beat cop has an IQ of 95. Which means they are less intelligent than the average person. They are on the downslope of the bell curve.
Yeah, they're not even allowed to be over a certain IQ, which was funny.
I don't think the average cop knows anything. But when we went down as a group to serve in Indianapolis to serve the status docs, when the Attorney General of Indiana, he shook my hand and goes, "Are you a resident of Indiana?" I said, I'm domicile. He turned 3 shades of white when I said that. So I think that they definitely know. Some people know, and some people are just parrots.
The higher ones up definitely know. And when you start talking in absolute correct language 100% of the time, it freaks them out, because what did he just do? He just tried to goad you into basically an agreement of a contract saying that you were an inferior citizen of the United States, that you were a resident of Indiana. And the second that you said, no, I'm domiciled, in a way like that, in a straight voice, smiling at him, being like, I know what you just tried to do, don't even try it. That would that would definitely freak him the fuck out. So it makes sense that he would turn white. Yeah. So, yeah, I'll just wrap up for the night. So thanks everybody for coming. If we want to do another follow up with this on another Saturday, like maybe after I get the writ done, that'll be great. I can kind of do it as a finishing up. Almost make this like a 2-part, and then also make sure that everybody gets the information to either Viper or myself regarding anything else you can find on writs of Quo Warranto, specifically, obviously, to going after those that are in office that should not be. Okay, so with that, this has been the Vocational Science Freedom Saturday Night Civics and Sovereignty class, and tonight's topic has been high prerogative writs and Quo Warranto, and I hope all of you enjoy the rest of your weekend. Thanks everybody for showing up. I welcome everybody who's new here. I hope you had a wonderful time. And until next time, as always, stay safe and stay sovereign.